All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Thank you. Please be seated. Can you call the case, please?
Good morning, Your Honor. This is file KSC CA 2024-03, the Specialist Prosecutor versus Pieter Shala.
Thank you. Good morning and welcome, everyone. I'm Judge Picard, presiding judge in this case. Thank you. I will ask the parties and counsels for victims to introduce themselves and their teams, starting with the Specialist Prosecutor Office.
Good morning, Your Honor. For the SPO today are appearing Line Pedersen, our case manager, Ella Palsenberg, our legal intern, and Sarah Clanton and Filippo De Minicis, prosecutors with the SPO.
Thank you. Now I turn to the defense.
Good morning, Your Honor. I'm Mr. Jean-Louis Gillissen. I am here with my two co-counsel, Mr. Awini and Mr. Leto Cariolo. We are here with an Associate Legal Officer, Ms. Janeta Petrovica, another Associate Legal Officer, Ms. Kaylee Chen, an Assistant Legal Officer, Judith Kolb, Legal Assistant, Alana Gonzalez, and a Legal Intern, Alozia Mombonza. I have to say we are here with Mr. Shala by video link, of course. He appeared from the detention center. Thank you very much.
Thank you. Next, I'll turn to the counsel for victim. Can you introduce yourself?
Good morning, Your Honour. I'm Simon Laws, counsel for the victims in this case, together with my co-counsel, Maria Radziowska.
Thank you. So I note that Mr. Shala is not physically present in the courtroom, but is attending the hearing via video conference. Before we start, I would like to recall that Judge Ambos, Judge Jorgensen, and myself have been assigned. I forgot to ask the registry to introduce themselves. Jonas.
Thank you, Your Honour. I'm hiding back here.
Yes.
Jonas Nilsson, Deputy Registrar for the registry today. Thank you.
Thank you. So before we start, I would like to recall that Judge Ambos, Judge Jorgensen, and myself have been assigned to the Court of Appeal panel to decide on the appeal against the trial judgment issued in this case on 16 July 2024. In accordance with Rule 178 of the rules, the purpose of this pre-appeal conference is to give the accused the opportunity to raise issues in relation to his detention, including his mental and physical condition. To this end, on 4th September 2024, I issued an order on behalf of the panel to convene this pre-appeal conference and to set out the agenda to be followed during this hearing. For today's session, I would like to remind everyone that a few rules must be observed at all times in order to have effective courtroom proceedings with an accurate record. Bear in mind the necessity of an accurate interpretation, which requires a bit of additional time, sometimes after you have finished speaking. Please rise to ask permission to speak and do not forget to use your microphones. This hearing is transcribed in real time and will be reflected in a transcript available to the public. I remind counsel to give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. Today's hearing will be conducted in compliance with the agenda set forth in the scheduling order. I will first hear submissions related to the accused detention. I will then invite the registrar to make submissions on any further update on the progress made on the official translation of the trial judgment into Albanian and its expected finalization. I will finally hear submissions on any other issues. In that regard, I recall that the defense of Mr. Shala informed the panel that they would like to address 3 issues. I also note that the SPO and the Council for Victims indicated that they do not wish to raise any additional issues. Accordingly, I will first invite the defense to raise any issues related to the detention of the accused. I remind counsel to request that we go into private session should they wish to refer to any confidential information related to the health or any medical condition of the accused. Now, counsel for Mr. Shala, you may proceed.
Thank you very much, Johanna. Thank you very much. So the first thing, perhaps, it's about the mental and physical condition of Mr. Shala. We have nothing special to say, to report about that, accepting the fact that I'm sure you are aware about the family situation of Mr. Shala and some problem he met with it. So there is some consequences on his moral, but I can say he's absolutely able to appear before the court and to attend this trial. So it's very clear. Second, about the detention of Mr. Shala, I have to say, of course, we warn him with the new kind of rules at the state of the procedure about the detention. And after all those explanations, Mr. Shala asked us to introduce a request. So we will deal with it as soon as possible and in the better timing it's possible. We are monitoring the situation with a very special situation of the family, and we will go back to you if it is necessary, of course. Thank you very much for your attention.
Okay, thank you. Mr. Prosecutor, would you like to say anything on this topic?
No, Your Honor, thank you.
Victims' Counsel, would you like to say anything on this topic?
No, thank you.
Thank you. With respect to the accused's continued detention during the appellate proceedings, I, on behalf of the panel, recall that pursuant to Article 46(8) of the law, unless the trial or court of appeal panel orders otherwise, a convicted person shall remain in custody pending an appeal. I further recall the appeals panel finding in case number KSC CA 2022-01, found that contrary to the phase prior to conviction in the first instance, where a pretrial judge or trial panel are required to conduct a bi-monthly review of detention according to the rules of procedure and evidence and the law, this is no longer required during the appellate proceeding post-conviction. The next item on today's agenda pertains to any further update to the progress made on the official translation of the trial judgment into Albanian. I already note that the unrevised translation of the trial judgment was filed on 4th September 2024. Could the representative of the registrar's office take the floor, please?
Thank you, Your Honor. Indeed, I can confirm that the unrevised translation was finalized and filed on 4th September. It was an unrevised translation, so it has not been formally served on Mr. Shala, but it's available to him and counsel through legal workflow, so that's F00847. The revised translation is still expected by the end of October, last week of October. Thank you.
Thank you. I will now turn to the last item on the agenda, namely the 3 issues the defense of Mr. Shala would like to address. First, the fact that the public redacted version of the trial judgment is not available yet. Second, that the defense intends to submit a request for an extension of both the word and time limit for filing its appeal brief. And third, that the defense would like some guidance with regard to any appeal against the trials panel reparation order. I will first turn to the second point, namely that the defense intends to submit a request for an extension of both the word and time limit for filing its appeal brief. I remind the defense that such requests shall be made in writing and filed sufficiently in advance to enable the panel to rule on the application before the expiry of the relevant time limit. And I remind everybody, although it's a confidential decision, that the decision was made yesterday about this specific topic. So I don't know if you want to make any more submission on that.
Thank you very much, Your Honor. So I think it could be an error, but I consider that that's a little bit of all. I want to say that we have this problem of translation. Could be nice if Mr. Shala, because he would like be able to utter some words to you to explain exactly his situation, and then I will come back on this, because I consider that problem of translation, the timing of consequences of this problem, and the request for an extension of time limit and limit of words are linked, and I'm able to explain it in a few words, of course, no reason to be long, but it could be nice first to hear Mr. Shala.
Okay, I will hear Mr. Shala, but then I remind you that if you want to have another request for extension of time and word limit, perhaps you could submit a request, written request, so that the panel will rule on it. Because I'm not going to rule on it today on that topic, but of course we'll examine your request, your written request.
You're absolutely right, and you can be sure you are fully aware about that.
Thank you.
We will be very attentive to this situation. Thank you.
And Mr. Shala, you want to say a few words?
Yes, good morning and greetings. Your Honor, I have a grave concern to raise regarding the previous hearing on the 16th, 17th and 18th. In only 3 days, we were able to find 213 words that had been changed. They were not errors in translation, but they were utterly different. I do not have the document in the Albanian language, and having noticed how the proceedings unfolded, I was a bit baffled and inattentive, because I wasn't even aware that words could be changed into another one. But on the 15th, 16th, and 17th, we were able to certify that there were so many changes, not simple errors, the mistakes that distort the entire meeting. I have not got the judgment in my possession, and I do not know how would we be able to appeal, given that the reasoning is there. There has been a judgment that has convicted me of murder, and I have never murdered anyone. However, given that the document has not been given to me officially to enable me to read it, to understand the reasoning as to why I have been convicted. So at this stage, I do not know how I would be able to go on.
I don't know exactly what you are referring to.
Personally,
Which hearing you are referring to?
voor persoonlijk en perform.
I meant the final one where I had the opportunity to have the floor on the 15th, 16th, and 17th. I can't recall when.
Okay, so I understand. That was the closing submission at the trial? Yes. Okay. So I hope that the translated judgment will come as soon as possible, by the end of October. We'll now turn to the second point, namely...
Your Honor, may I?
Yes.
Yeah, thank you very much. So I want to say that we have the idea that for the registry, the possibility to issue a report explaining the judges, the parties, the victims' counsel, with the difference between the unrevised version and the official and definitive version, a report about that could be very helpful for all of us. We could win a lot of time. It could be very, very nice for the efficiency of all of us. And I consider that because the translators are part of the registry is at the best place to issue such a report. So that's my suggestion.
I see that the registrar agrees and will probably do its best to make a report on that subject.
Thank you, Your Honor. Yes, we would be able to make a comparable version so you can see what has been changed from one version to the other. Yes, no problem. Thank you.
Thank you. That was... so I will now invite the defense to make submission on the remaining issues, 1 and 3. So issue 1 is the issue 1 is the fact that the public redacted version is not available yet. The second issue, we spoke about it already, that is eventually a request for an extension of time limit and word limit. Okay, so now the third point, can you take the floor on the third point?
Yes, Your Honor, we would like to utter some words about the reparation procedure, and with your leave, Mr. Awini is able to explain our position about that. Thank you.
Good morning, Your Honors. We're glad to appear before Your Honors today in this hearing. Your Honors, I'll address the reparations order, and the remaining point will be the publicity of the trial judgment, which Ms. Cariolo will address later, unless Your Honors wants to address that point before.
Yes, I would rather, yes.
Okay, then I'll leave the floor to Ms. Cariolo to address that point, and I'll be back for the reparations. Thank you, Your Honor.
Your Honors, very briefly, as known, Mr. Shala was convicted on the 16th of July. And although the fact of his conviction and sentence is known, the reasoning in support of that conviction and sentence remains unknown to this day to all but the few privileged ones with access to the confidential version of the trial judgment. And we would just like to express our concern because not only Mr. Shala would like to have a public redacted version of the trial judgment, and as it is his right to be tried in public, his family, his friends, other accused before this tribunal, and the lawyers, the academia, the media, and ultimately the public also has a right to be in a position to follow these proceedings. And the fact that the trial judgment to this date, 2 months after it was issued, remains confidential together with the fact that the final briefs remain confidential, our notice of appeal could not be filed in a public redacted version, it is a problem, together with the fact that the defense was previously prevented from discussing in public certain aspects of this case, certain aspects of the prosecution's case, which in the view of the defense have been scandalous. We just want to express our concern that these proceedings are very close to be conducted behind closed doors, which is not, of course, acceptable. We understand that it is not within your panel's competence to issue the public redacted version, but we just wanted to share our concern about this situation. Thank you, Your Honor.
Thank you. Yes, I agree with you that the proceedings and submissions filed before the specialist chamber should be public. But to the extent possible, or when this is not feasible, that public redacted version of such filings should be made available in a timely manner. However, and as the defense is well aware, there are also security concerns which may constitute exceptional reasons for keeping some information confidential. And I recall the indication that was given by the trial panel on the day of the pronouncement of the trial judgment, namely that the public redacted version of the trial judgment will be issued in due course, so it should be made, I repeat myself, available by the end of October. And in addition, the panel has already taken steps to ensure that the appellate proceedings will be public vis-à-vis Mr. Shala and the public, and will continue to do so. In that regard, I would like to remind the party that the notice of appeal and related subsequent filings will have to be reclassified as public or made available through the filings of public redacted versions once the public redacted version of the trial judgment is issued. In these circumstances, I do not consider that the fact that there is no public redacted version of the trial judgment would, at this stage, interfere with the accused's right to a public hearing. Also, we are all aware that this pre-appeal conference is held in public. So now, may I... So as far as I hear, I mean, it's not even sure that the public redacted version of the trial judgment will be issued by the end of October. So it might be hopefully before, but we don't know. So I can only say it will be issued in due course. And I believe that the registry is doing its best to issue it.
May I, Your Honor, with your leave, to add just something. First, of course, we thank the Register for the effort to provide us with this unrevised document we receive, and I'm sure all of us, we are making a real effort to be able to work properly as soon as possible. And that's why I want to say and focus on the fact that the request we will introduce about time limit and work limits will be introduce a very reasonable asking, I have to say that. But the very next few days, we have the feeling we could have a problem. When I say we could have, I don't speak only about the defense team, but for all of us. Of course, you can imagine we are, of course, following the other cases pending before the KSC, the Kosovo Specialist Chambers. And we have learned that some witnesses in public hearing were talking in their testimony about what's happened in Cooks or about what is concerning Mr. Shala. And it seemed obvious they continued in non-public hearing to speak about that. So we asked to the prosecutor to be attentive to the situation because he is not the judge, but the one who is able to provide us with some elements if it is needed. But I'm a little bit afraid we received an answer to say, no, there is no problem, and I trust the prosecutor. But I know that the prosecutor in the past confessed some difficulties sometime with this kind of situation, and with a good faith. There is no discussion about that. An error could be committed. So it could be nice if the prosecutor could be able to take a look with a particular caution about that, because some new information, some information that could be used by the defense in this appeal could appear. So that's why I would like to underline it. And thank you very much to providing me the possibility to say that. Thank you very much.
Thank you. Mr. Prosecutor, do you want to react?
Just briefly, that we are aware of our continuous Rule 103 obligations to disclose exculpatory materials. So we review the transcripts in the other cases to that end, and we will disclose any material that is prima facie exculpatory to the defense. On another unrelated note, but just to clarify the record, I think on page 12, I want to correct the fact that the pretrial briefs have been filed publicly. There is a public redacted version of the prosecution brief. There was a defense version. Then it's been ordered that that be reclassified as confidential. But as far as the prosecution brief is concerned, there is a public redacted version on the record. The final trial brief, there is a public redacted version on the record.
Thank you. Thank you. Now, the last question is the defense request for guidance with regard to the appeal against the trials panel reparation order. I will hear you, yes.
Thank you, Your Honor, for the opportunity to address this issue of importance to the defense. So on the reparations order issue, Your Honors, and the potential appeal of that reparation order, Your Honor are well aware that since the conviction, the trial judgment convicting Mr. Shala in first instance, trial panel 1 has retained jurisdiction for issuing the reparations order, and this one would be expected in the next weeks or months. And obviously the defense will be contemplating, since we are filing a notice that we disagree with the trial judgment, we will be seriously contemplating appealing that reparation order. Now, having a look at the law and the rules, we have a certain reading, and we will develop it before Your Honors in order to confirm it or clarify it if necessary. Our reading of the rules, and particularly the law on Article 44, seems to suggest that reparations, which is part of the article on punishments, is something akin to or part of sentencing. If that understanding is correct, we understand then the assignment of the appeals panel to the appeals proceedings of the trial judgment will automatically include any reparation order. And so it is expected to cover that reparation order. And this is the reason why we seek this guidance at this stage, at an early stage, before Your Honors. Our request is basically to clarify and issue guidelines on the applicable procedure to appeal that order when it comes to the issuance of a notice of appeal on that reparation order and the brief, as well as the time limits and the word limits applicable to that reparations order's appeal. And this is mainly to avoid a situation where that is similar to what happened in the Mustafa case, where the reparations order was not discreetly appealed on a separate notice, and a very slight mention of it was made in the brief, which was dismissed based on the fact that the reparations order was not appealed. So if your honors have a different reading than ours, and you believe that since the jurisdiction is still with the trial panel for that specific order to be issued, that decision to be ordered, and a new assignment will be needed at the point where that order is issued for an appeal procedure for it, we will need your honors to clarify that so we can seize the president at the moment that document is issued to seek the guidance at that moment and the timelines. If your honors consider that you have already the mandate to issue the guidelines and the modalities of that appeal, it will benefit everyone to have that clarification. If the applicable procedure for appealing a sentence is the one that is applicable to any reparation order, it has an impact on our timelines, the tax, the focus, the tasks that we need to undertake, and the focus of our efforts. Your Honors, this is the request that we are making in order to, as early as possible, be sure that we can exercise and defend Mr. Wright and Mr. Shala's right to challenge any decision issued by the court in a timely and an efficient manner. I hope, Your Honor, our request is clear, but we're happy to make any further submissions.
Thank you for your views. Yes, your request is a little bit premature at the moment, as no reparation order or judgment has been issued. Does the prosecutor wish to say something about?
No, Your Honor, thank you.
And the victims' counsel?
Well, we agree that it's premature, but at the same time, it is also our view that there is a lacuna in the rules in relation to the time limits and the procedure for appealing a reparations order. We have our own view about that and what the outcome should be in terms of a decision by Your Honour and Your Honour's colleagues. But we'd suggest that it's something which is much better addressed in writing rather than orally, and it may be that a direction or perhaps an indication could be given that this matter should be fully briefed, and we'll address it in that way with your leave.
Yes, I agree that something in writing would be easier, and the appeal panel will try to provide guidance quickly after the reparation order is issued. Has anyone something to add? No. So unless anyone has something further to add, this concludes today's hearing. I thank the parties, counsel for victim and the registries for their attendance and contribution. I also thank the interpreters, stenographers, audiovisual technician and security personnel for their assistance. The hearing is adjourned.
All right.